Hello, my name is Nicole Pottroff. I'm an associate attorney at Koprince Law. Today I want to talk to you about the stay of performance feature of GAO bid protests. This feature originally comes from the Competition and Contracting Act and is therefore commonly referred to as the CICA stay. First, why does the CICA stay matter? When you're protesting an agency's contract award as the unsuccessful offeror, getting a CICA stay can make a world of difference. With the length of time it takes to resolve a protest, sometimes over 3 months, the awardee's performance of the contract could be well underway or even completed before GAO ever reaches a decision. In that case, even a decision in your favor may provide you little to no relief as the protester. In many cases, a win at GAO isn't a win at all without a CICA stay. This is especially true for the incumbent contractor. Without a CICA stay, they would have to stop performance and take part in a burdensome transition to the awardee, one that may have been totally unnecessary depending on the outcome of the protest. So as you can see, a CICA stay can be vital to a meaningful bid protest. Now, how do you get a CICA stay? Well, like all things at GAO, there are strict timeliness rules. These rules can be found in the CICA itself and in the FAR. Basically, for GAO to implement a CICA stay for your post-award protest, you must file within 10 days of the award. But where a post-award debriefing is required, and you request the debriefing, you have 5 days from its conclusion to file your protest. So long as you file in that time, a CICA stay is required. So how does it work? A CICA stay essentially puts the awardee's performance of the contract on hold while your protest is pending. Specifically, it prohibits the awarding agency from authorizing performance once the agency receives notice of your protest. If performance has already begun, for example, if your debriefing doesn't come before the start date, the contracting officer must immediately suspend the performance. So does the agency have to stay performance? Generally, yes, but the CICA and the FAR do provide an avenue for the agency to override the CICA stay. The agency must make a written finding that performance is in the best interest of the United States, or that urgent and compelling circumstances don't allow it to wait for GAO's decision. And the agency must notify GAO of this finding. But without making this finding and notifying GAO, the agency should be bound by the stay. Unfortunately, if the agency fails to abide, there's absolutely nothing GAO can do about it. So what do you do if your CICA stay is ignored? The only thing you can do is file a protest at the Court of Federal Claims to the agency's de facto override of the stay. This is not an easy or cheap solution most of the time, but the court has the power and authority to enforce the CICA stay in a way that GAO simply does not. So if an agency has ignored your stay, this is your best bet to protect your rights as the protester. And as I've explained, this is many times a right well worth protecting. For further questions and for help pursuing your bid protest and your CICA stay, give us a call at Koprince Law. And please do subscribe to see more of our government contracting videos. Thanks for tuning in.